Hello again, everybody. Bob from Florida Cam Courses here. We're very excited to bring this Manager's Minute to you that's going to last way more than a minute. But we have Gregg Casalino from O'Hare, Quinn, Casalino Chartered. Uh, Fantastic attorneys. And Greg deals with real estate, association law, and he was gracious enough to spend some time with us today as we go through some of these new statute updates. And hopefully, if you're a board member, you'll get some great tips out of this. At the end of our interview, I'll give you Greg's phone number if you'd like to reach out to him for more information. So, Greg, the first thing that affects a lot of the management companies was the updated Estoppel law. From the buyer's perspective, what kind of information should be included in that they should be looking for?
So the first and foremost, obviously, is the money. How much are current assessments, what's presently due, what's coming due. But in addition to that, they've now specified a breakdown of assessments for master association and what we refer to as a sub-association. In many large communities, there might be a master association that handles operations for the overall community, and then individual sub-associations which control, for example, particular condominium buildings within that community, or even just neighborhood clusters of homes or courtyard homes or townhomes. And so the new Estoppel certificate requires that those amounts all be broken down. In addition to that, and from a buyer's perspective, something that's very important is to know that they're required to now list is, are there any rule violations? So outside of money, there's the use of the property that can be very important to know. If there's any pending violations that could be resulting in fines or other issues with the property that wouldn't be readily observable. An example might be a wrong paint color.
So legally, does the violation follow the occupant or does it follow the property?
So it could potentially follow either, depending on the nature of the particular violation. If it's for example, violation of a pet policy and that seller moves out, that's going to cure that violation. But if it's, again, something having to do with the landscaping or the exterior appearance of the property, obviously that's going to stick to the land itself.
As it relates to an HOA?
As it relates to an HOA or a condominium.
Well, from the seller's perspective then, which I assume most times the seller is obligated to provide this Estoppel form, what's the cost going to be?
So one of the things that the new Estoppel certificate law imposed is some maximum charges that can be charged for that Estoppel certificate. It's now $250 for the certificate, and in addition, there could be a charge of an additional $100 if the certificate is required on an expedited basis, which we often see where there's a flurry of activity at the contract stage and then everything goes quiet and there's a flurry of activity immediately prior to closing. People are rushing around trying to get everything together at the last minute for this closing, and the property managers, if they've got to drop everything to take care of that Estoppel certificate, they're entitled to a supplemental $100 fee on top of that. In addition, if the account is delinquent, then there can be another charge of $150. So now you're looking at the potential for that Estoppel certificate being as much as $500.
Do you know off the top of your head what qualifies as expedited? Is it like 0 to 10 days if you need it that quick?
So off the top of my head, I believe the new statute says 3 business days.
Anything after that is a normal?
Correct.
Okay. So we get our Estoppel certificate. We're moving forward with the closing, and then the deal falls through. How does that affect the buyer? If the buyer doesn't close, what happens to the certificate, and what happens to the money that was paid for that?
So that certificate's good for 30 days, but it is important to know if it doesn't close and that buyer can provide written documentation to the association, then and they've paid it, then they're entitled to a refund. It's important for a seller to know that if the association refunds that estoppel certificate fee to the buyer, they can look to the seller, their owner, to have to reimburse the association for that amount that's been paid back to the buyer. And if the seller doesn't immediately pay it, then the association can treat that amount like an unpaid assessment.
Really? That's very interesting. Is that new?
This is a new part of the statute. Now, of course, a buyer and a seller in Florida are freely able to negotiate who pays what in the real estate contract, but it's an important thing that can be glossed over and become a problem only when it's a problem.
Can the property close without an estoppel in a planned community?
So the title companies are in fact going to require that estoppel certificate, and the law is quite clear that this new form is the form to be used.
So it's standardized throughout the state.
Standardized throughout the state.
That's good information. Pay attention to that, managers. Let's switch gears a little bit. We'll get back to the buying and the selling part in a minute, but something near and dear to me is boardmanship. A lot of communities are having a hard time getting the volunteers to serve on the board. A lot of folks that want to serve, for instance, a renter, a non-owner occupant, they don't always get the opportunity to run for the boards, and that may be the next place we have to go to. But can non-owners be board members?
So in fact they can under the law, but the association's bylaws, articles of incorporation, and declaration need to be reviewed carefully, because typically where we see a restriction on board service being limited to owners is in the governing documents as opposed to the law. But that is not to say that if the governing documents don't prohibit it, that non-owners can in fact serve.
So if the documents are silent, then pretty much anybody in the world can run for that board position?
Pretty much anybody can run for that board position, yes.
So check your documents, managers, board members. Specifically, I would suggest you look in the bylaws. That'll usually tell you what the requirements are. And it's also where the duties of a board member would be as well. So you definitely want to look at that before you take the plunge to run for the board of directors. So let's get back to the buying and selling. Now, as a buyer, what should I be looking for with documentation? You talked about the governing documents. What am I entitled to see as a buyer, non-owner yet?
So what's normal for buyers to be seeing are the recorded documents, the declaration, the articles of incorporation, the bylaws, those things that are in the public records are filed with the Secretary of State. But when I represent a buyer, I often suggest that they look carefully at the association's current budget, proposed budget, with a specific emphasis on what sort of reserves there are. Some buyers aren't too concerned about reserves and have the financial resources, along with the neighbors in that community, to pay a special assessment if the need arises. Other buyers would much rather see a community with healthy reserves so that there's a good rainy day fund. One of the other things that I often suggest to my buyers that they request, and it's not part of the public records, are association board and members meeting minutes for the past year, so that they can get a feel for what the issues of debate are within the community.
Is the buyer entitled to meeting minutes?
So they're not entitled to them under the law, but in my experience, I've never seen a seller who was uncooperative about providing those documents upon request.
So if you request them from the association and they refuse as a buyer, the buyer should contact the seller, who's absolutely entitled to those
The
documents.
seller is absolutely entitled to those documents. Those are official records of an association, be it a condominium or an HOA.
Excellent. Good news. Now, this is something that I've experienced because I've done a fair amount of developer-controlled associations, where the developer, in order to effect a sale, gives special consideration to the buyer, whether it be a oversized dog, or perhaps they allow a certain vehicle where the document's restricted. Can a developer give somebody a waiver from certain rules?
So quite often they can, particularly if the developer is selling during the period of time where the developer is in control of the association. Most sophisticated developers in Florida will write language into their governing documents, giving them broad powers and discretion during the period of time that they're in control. What's most important, and what we've seen in the past where trouble arises, is there's no paperwork backing up that developer waiver. So if I'm a buyer and the developer has said, no problem, you can, if you buy this house from me or this condominium unit from me, you can bring in your oversized animal. It's important that that buyer get that in writing, and that written waiver be made a part of the association records so that they're protected.
And does that hold true for like outbuildings in an HOA where the developer allowed them to put up a shed?
It can quite often. Again, one would look to see that the governing documents give the developer broad discretion.
And how do you recommend the board handle the future battles that are going to come down where I want a shed too because my neighbor has one?
So boards have the right to, and we're talking about boards after developer control is turned over to the owners, those boards, and each board each year operates on its own and is not required to give waivers because the developer did. So if they have documentation in their governing documents that is specific to that particular issue, my advice is to follow those documents.
It's basically their charge. Wouldn't it be, I don't want to use the word illegal, but wouldn't it be improper for the board to not follow the documents?
It would be, unless the documents provide greater discretion to the board. We do see some documents upon occasion that give the board the right to grant waivers and exceptions under specific circumstances. It might be a hardship situation, but if the board was to do that, one of the things that we often recommend is that it be tied to the owner, not the property, so that that exception doesn't run with the land. If that
Makes sense.
Seller or owner then sells the property, that waiver ends.
So board members and managers, again, read those documents, read the bylaws about what your responsibilities and any latitude you may have. You want to look for certain words. May is not shall. So, if it says the board may allow a concession, then that's up to that individual board. If it says that the board shall not allow concessions, then you can't. So, sticking with the rules thing and what associations can do, are the associations limited to their, particularly in HOA, architectural reviews, what they can require of us? Can they be super restrictive? I've seen so many odd things where people are allowed to go off the painting palette, and the ARC said, no, you can't do that because it's not one of our approved colors. Seems kind of restrictive that they have approved colors, but what authority does the Architectural Review Committee have in an HOA specifically?
So several years ago, the legislature actually passed a law on this particular subject, circumscribing the discretion that an HOA has with regards to architectural criteria and guidelines. What we advise our clients is The more specific, the better. But within those specifics, and let's use paint color as an example, if there's a palette of colors, they cannot tell an owner, you must use this color or that color. If there's a range of colors, as long as that owner is picking something within that range, they're entitled to do so. The association is not allowed to act in an unreasonable manner or an arbitrary manner or otherwise try to pigeonhole an owner as long as that owner is complying with the guidelines as written.
Sure.
So again, what we advise folks when they're looking at drafting or revising their architectural criteria is to be as specific as possible.
I've seen them as specific as you cannot paint your house the same color as a neighbor or the house across the street. So if anybody else has that color, you're kind of out of the way on that. I guess it's important to discuss also that architectural review, board powers, association governance in general was pretty much all settled as far when the buyer purchases the property. They entered into a contract with the association. Would that be fair?
That's right.
And with that contract, you said, or the buyer says, that you've read all of the association documents and you agree to abide by them. So now you have an agreement or a contract with the association saying, I'm cool with no pets, I'm cool with the paint colors, and I want to live in your community. So rule enforcement is almost contract enforcement.
That's right. And those rules apply not only to that owner, but to the owner's guests and tenants.
So everybody who comes onto the HOA or into the condo is responsible whether they know the rules or not. And it's the owner's obligation to enforce them, that we don't allow wet bathing suits in the clubhouse or something like that.
The buck stops with the owner.
Very good. So remember that. It's contract managers. That's what gives us the authority to enforce the rules in the first place. We're acting as agents of the association, and the agents through the management contract or your employment agreement gives you the authority to act on behalf of the association and enforce that contract. So a big hotbed for boards now is the law was updated that allows certain communication by email. What can they discuss outside of a meeting by email?
So they can discuss a wide variety of matters, but what they can't do is vote.
So they're not allowed to say, I'm in favor of this landscape contract, or can they? Because does it have to be a formal vote, or can, if you give an opinion that I'm in favor of this contract, is that a vote?
I would say no, that just discussion is going to, by its nature, include some back and forth and opining by the board members. However, if they then take that I'm in favor and turn it into action, that's a vote. And again, in those circumstances, even though they are allowed under the current law to communicate by email, what we advise people to do is notice the meeting and then follow up with a properly noticed open meeting vote on the subject.
So as a follow-up to that, as a board member, I get an email from the manager telling me that attached is a new contract for a landscaper or a air conditioning contractor. Tell me what you think. And I do tell the manager what I think. Is my email on my personal computer subpoenable?
So this is an interesting question with regards to a personal computer. The email is not subpoenable from the board member. However, there is an older state attorneys general published opinion that says that any communications to the property manager would be discoverable and are actually part of the records of the association.
On the management company
On the
side.
management company side as opposed to the owner. Now, one of the other distinctions here is, as you just said, you use the words personal computer. And if it's an owner's personal computer, that's one thing. However, we often see communities where there's a dedicated email system that the board members use. That is not a personal computer.
Fair enough. Again, we've had a lot of laws passed last year in July that kind of brought a little parity to HOAs versus condos. But a big thing was official records. I've always been a proponent that you keep everything as long as you possibly can. You can digitize them and store them easily. 7 years has always been the basic rule. But my understanding of House Bill 841 is that some records are now kept in perpetuity. Is that correct?
That is correct. That is correct.
So you just can't throw away. Would that be like old declarations that have subsequently be amended, or can they be thrown away?
No, those documents should be retained. Again, what we're fortunate in the modern world is the ability to scan and digitize these documents.
So no longer having storage buildings all over town.
That's right.
That's one good thing about technology. Well, in closing, we're going to take a question from a viewer, and I'm sure this is on everybody's mind. We live in a pet-free community, and I want to have my companion animal live with me because the doctor says I need a companion animal to replace my lost spouse. Boards are struggling with this throughout the country, and particularly in our state. At one point, you advised me to ask the person looking for the concession under what act they were claiming benefits. And I was wondering if you could just tell our viewers the difference between fair housing and ADA, and does the ADA apply to companion animals?
So it very much can. The FHA law is the Fair Housing Act, and the Fair Housing Act prevents discrimination based on, among other things, matters under the Americans with Disabilities Act. What I advise boards to do when faced with this problem is to require documentation, and that means proper documentation. An offhand note that doesn't tell the board anything with regards to why that emotional support animal is required would not be sufficient. Now, a board's not entitled to ask for specific medical information, which would violate a person's privacy rights.
HIPAA rights, right?
Their HIPAA rights, exactly. But they can, in fact, ask for sufficient documentation supporting the need for that support animal. And there are all sorts of horror stories out there in association world with regards to people going to extremes. We've seen in the news emotional support peacocks and
Sure.
and other sorts of things, and it can be a subject of abuse. That's why it's important to ask for proper documentation. And in fact, the Housing and Urban Development Department and the Justice Department published guidelines a few years ago that are freely available online by just looking up emotional support animal HUD, Justice Department in a Google search. You'll find these published guidelines that lay out in really good detail what an association and its board can and cannot ask.
Do you recommend that a board be proactive to this particular scenario and work with their association attorney to establish these rules and policies in advance as opposed to being reactive to someone coming in and saying, this is my service alligator?
I absolutely think that whether it's an alligator or a peacock or a house pet, that it's important for association boards to work with council to have established guidelines so that they're not in a position where they're either trying to play catch up or exposing the association to potential liability for a Fair Housing Act violation, because recent changes to the law of this subject have established that discriminatory intent is no longer required. All that has to happen is there is a discriminatory effect.
And that's pretty subjective. If the person feels discriminated against and can prove that they were, the pendulum swings to the side of the occupant that is looking for the animal.
Exactly. So it's important to make sure that the proper steps are followed in a uniform fashion.
And then, the companion animal and emotional support animal, those are a little tough sometimes for people to swallow, but they are real. They do have a value. Sometimes an association can ask what service this animal provides. I've seen animals that can detect an epileptic seizure oncoming, or someone that is having some sort of anxiety attacks. The animals somehow know how to calm the person down. But where I wanted to end this with the service animal part, whether it's a seeing eye dog or an animal that assists an amputee, what's your advice to boards about the differences between service animals and companion animals, and what right does the board have to not allow a service animal?
So they really have very little right to not allow a service animal. And there is a very big difference between an emotional support pet and a service animal. That service animal is essentially like a medical worker, as opposed to an emotional support animal. And there are very strong protections for service animals, just as we see in business operations in a store or an airline or whatever.
Whether an association is a pet-free community or not, as it relates to a service animal, they have no dog in this fight, so to speak.
So to speak, that is right.
Well, that's all the time we have for this month, folks. Thank you so much for joining us. Gregg, thank you for coming. I appreciate it.
My pleasure, Bob.
And if you'd like to hear more from Gregg Casalino of O'Hare Quinn Casalino Chartered, you can give Gregg a call, and the number will be at the end of this video, but his number is 772-231-6900. Thanks very much for spending some time with us. We'll see you next time. Take care.